on all platforms. Let me know once we are live. Oh, okay. Good afternoon, ladies and gentlemen. Good afternoon, good morning, good evening. Wherever you may be watching us, thank you for joining our live podcast. This is Dr. Olu Asekun. Please invite your family, friends, colleagues, and join us. Today, we have a lot to discuss. Um, I was actually preparing for something completely different for today. Before the new memo on adjustment of status struck last week, and I know that there's a lot of people who have questions regarding the new policy. I've received series of calls, text messages, emails, and all of that. But I have deliberately declined to respond to any of them before now for several reasons. I mean, for those who are regular listeners on this program, you know that I'm not in the habit of giving rumors or giving information that I cannot verify. That is not my style. So the memo is out. It's out there. Everybody already knows about it. But there are a lot of unanswered questions, even in the memo. There are a lot of things that even USCIS have not addressed in the memo. For example, what constitutes exceptional circumstances? They didn't define it. There are portions of the memo that I personally believe that is inconsistent with the Immigration and Nationality Act. And I foresee that this memo will be challenged in court. But in the meantime, because we are dealing with time, I'm going to start today's podcast the way we normally do it. That is to discuss updates and then go into question and answers. But because of the recent development, I will be spending significant time on the memo and some other updates. So this week, to start, the first thing I want to talk about regarding updates on immigration law between the last podcast last week and today. Number one, EOIR, in an unprecedented situation, appointed 77 new immigration judges last week, on May 21 to be precise. 77 new immigration judges. In fact, I read something very interesting on American Immigration Lawyers Association portal, lawyers portal. They call them deportation judges instead of immigration judges, because these judges were specifically appointed to just carry out the current administration's mandate of deporting people. And of course, it is the same policy of removing people from the US that even the new memo we are talking about is focusing on. So that is the first thing I want to announce. There are going to be new faces. There are going to be new faces at the immigration courts. We've been seeing different faces before, but now 77 additional immigration judges. And the specific mandate is for them to clear the backlog. The mandate is for them to clear the backlog. So, irrespective of everyone's situation, they are going to be concerned about speed according to the last the last information I had from EOIR, about 12 million cases are currently pending at different immigration courts across the United States. So, if you have immigration court trying to dispose of 12 million cases within 2 years, you know that's going to be problematic. It is going to be extremely problematic. But here we are, we will face it one at a time. The next thing I want to talk about, still talking about the current administration's policy of getting people out of this country. On Friday, I don't know why USCIS and EOR, they always release their policy on weekends. When people are about to go for a weekend, that's when they always release their policy. Holiday weekends. Oh, yes, especially these past holiday weekends. So last Friday again, ICE they released a new proposal. This is still a proposal, but of course, it's probably going to be adopted. They released a new proposal, and under the new proposal, they are going to be increasing the fee for removal in absentia. They are going to be increasing the fee for removal in absentia. The current fee, which again was under this Donald Trump administration, it was incorporated into the Big Beautiful Bill. The Big Beautiful Bill Act, BBBA. Okay, now, under that bill, the fee was $5,130, but now ICE is proposing to increase it from $5,130 to $18,000. $18,000. Now, I know those who are listening, you may be wondering, what is this fee all about? The One Big Beautiful Bill Act created a new enforcement fee for certain non-citizens for failing to appear at an immigration court. So in other words, if you have a removal order issued against you in absentia and you didn't even know about it, if you are arrested by ICE, for you to be able to get any relief, the first thing you will need to pay is $18,000. That is the proposal that ICE is making. So, number one, you didn't show up in court. Probably because you didn't receive hearing notice, or for whatever reason, you didn't show up in court. Then a removal order is issued against you in absentia, and maybe you didn't know about it. Maybe you are driving to work or doing something and ICE pick you up, and then you quickly rush to get a lawyer. Oh, file a motion to reopen, do this. According to ICE, the first thing you need to do is to pay $18,000 to ICE if you are going to regain your freedom. And meanwhile, paying the $18,000 does not even guarantee that your case will be reopened, or that you will even get a bond. But ICE is proposing that for those who get in absentia removal order and they are arrested by ICE, they will have to cough out $18,000. I'm going to remind my listeners, I know that I say this all the time on our podcast here. Please, if you are in this country, you are not yet a citizen, whether you have a pending case or not, if you have alien number, please always check the EOIRK status portal. At least check it once a week. At least. You may be wondering, how do I check it? Just go to Google. Thank God for internet. Just go to Google, type EOIRK portal or EOIRK case lookup, case status lookup. So once you type it, you will see the EOIR case status lookup. So click on it. It will ask you for your alien number, and it will also ask you for your country of citizenship. Those are the only information you need to provide. If you have a removal order in absentia, you will know. You will see it right there. One of the things that keep us doing this job is that we receive a lot of feedback from our listeners. And I've seen so many people who call this office to thank me that, look, because I heard from you, I checked the portal. This is what I found. Some, they have already been ordered removed. Some, there is no removal order yet, but they have a proceedings and they didn't even know about it. So always check. It is your responsibility. With the current administration, no stone is going to be left unturned in ensuring that people are sent out of this place. So play your own part. Check the EOIR case portal. Put in your alien EOIR case status lookup. Just Google it. EOIR case status lookup. Put in your alien number, put in your country of citizenship, and you will see if you have a removal proceedings against you or not. Especially, it is more important now that ICE is proposing 18,000. The question is, God, assuming that ICE arrested somebody because there is a removal in absentia removal order. If this person have $18,000 to put down, why will you even stay in the US? Why not just go back home and use the $18,000 to start business? I mean, this is, like I said, we are in an unprecedented time. But again, please play your part. Play your part. Do not allow all these things to meet you suddenly. I mean, be prepared. Play your part. Thank you. Now, I'm going to go into the policy. I'm going to go into the new policy. As I said, I've received several calls, email, text messages, and all of that. But I refrained from answering those messages because I wanted to have authentic information. There are a lot of information currently circulating online. Some of them are half-truth. Some of them are accurate. Some of them are not, they are complete falsehood. So I'm going to explain during today's podcast what the implication of the new policy is, who is affected, the limitations of USCIS itself, because the policy does not affect everybody applying for adjustment of status. And that is one of the misinformation that is going on social media. A lot of people don't understand the way immigration law works. Even I've seen information sent to me by people that were supposedly emanating from lawyers. Either those lawyers are not familiar with immigration law or they did not take time to review what the law is. But we are going to discuss all of these things. In order for me not to omit anything significant, I've put down a jot. I jotted some information so that I will address it one by one. Now, it is my belief that this policy will be challenged in court. Therefore, I'm going to advise my listeners to be a little patient because you can't rush to court to challenge a policy like this. In law, there is something called jurisdiction. Court will decline jurisdiction until until somebody who is affected by the policy is the one approaching the court. Right now, me as an immigration attorney, I can't just go to court on behalf of a client to say, oh, this policy by USCIS is unconstitutional or is unlawful or this and that, and file a lawsuit. The lawsuit will be dismissed immediately for lack of jurisdiction. There is something in law called local standard. You have to have the right to file a lawsuit. It is not every Tom, Dick, and Harry that can just go to court and file a lawsuit. You have to show how you are interested in the lawsuit that you are filing. You have to show how this particular policy affected you. Therefore, it is very premature for anybody to challenge the policy in court right now. So there is going to be a lot of patience. For anybody to be able to sue on this policy, USCIS must have taken a decision, adverse decision, affecting the person. Maybe when they start implementing it and they start denying people on the ground that they should have applied at the embassy, at that stage, that is when people can file lawsuit. Right now, lawsuit is not ripe. So if anybody is telling you lawsuit has been filed, this policy has been challenged and all of that, they are not being truthful. Nobody can file a lawsuit at this stage. So there's still going to be a lot of patience. So for that reason, I'm going to be discussing how we are going to navigate this, at least until we determine if and when a lawsuit will be necessary and what the court will determine. So that is the first thing I want to mention. Now, I also want to explain that adjustment of status is not the same thing as consular processing. That is another error that I see on social media. Some people don't even know what adjustment of status is. And a lot of people use the word adjustment of status interchangeably with consular processing. They are not the same thing. They are completely different. It is only somebody who is physically present in the US who can apply for adjustment of status. If you are applying for green card through the embassy, that is not adjustment of status. That is called applying for immigrant visa. So they are two different things. And the Congress created two different rules for these things. So there are some cases where somebody is allowed to apply for adjustment of status in the US by the Congress. The Congress created the Immigration and Nationality Act, and they make specific provision authorizing applicants to apply for adjustment of status in the US, not at the embassy. They may not even apply in certain cases at the embassy. It is not every applicant for adjustment of status. It is not every applicant for green card that can apply at the embassy. I will give you specific cases of application for green card that is impossible, legally impossible to process at the embassy. So it is very important that we understand that there is a big difference between adjustment of status and applying for immigrant visa at the embassy. This particular policy is addressing adjustment of status, but the adjustment of status does not cover every category. It does not cover all the categories. So, number one, this new memo characterizes adjustment of status as, I want to quote them now, administrative grace and extraordinary relief that permits applicants to dispense with ordinary consular processing. Like I said, there's a lot of misconstruction here. Even I've seen lawyers since last Friday that this memo came up who were interpreting this memo in a way that is inconsistent with what the law says. So I want you to note, my listeners, I want you to note the following about this memo. I want you to know the following about this memo. Number one, The memo only affects adjustment of status applicants who are able to seek immigrant visas abroad. This memo only affects adjustment of status applicants who are able to seek immigrant visa abroad. It does not affect categories that will adjust status under other provisions of the Immigration and Nationality Act. Now, Congress enacted the Immigration and Nationality Act. The memo is dealing with Section 245 of the Immigration and Nationality Act. That is the adjustment provision. And according to the memo, discretionary adjustment of status in the U.S. is what the memo is addressing. However, there are non-discretionary adjustment of status provision in the Immigration and Nationality Act. And these are some of the examples. So, the memo or the policy does not affect adjustment of status in the case of a refugee adjustment. If somebody entered the United States as a refugee, they are eligible to apply for adjustment of status after 1 year of entry into the U.S. They can only apply for adjustment of status in the U.S. They cannot do it at the embassy. This is a statutory provision. In fact, that is what the Congress specifically authorized. There is no option for the embassy to process an immigrant visa for a refugee. So, this memo, no matter how it is translated, does not affect somebody who is applying for adjustment of status as a refugee. The memo does not affect them. The second category of people that are exempt specifically from the memo because Congress created a specific authorization for them to be able to apply for adjustment of status in the United States. They are EB-5 applicants. EB-5, investors. If you are an investor and you invested, I believe currently it is 800,000. If you invested 800,000 or 900,000, 800,000 through regional center or 900,000 through do it yourself, and your I-526 immigrant petition for immigrant investor, I-526E, is approved, according to the United States Congress and as enacted under Section 245N of the Immigration and Nationality Act, you have two options to apply for green card. You can choose to apply for adjustment of status in the United States. It is authorized by the statute. This policy does not even address it. They don't even have the authority to change a law enacted by the Congress. So, an investor can apply for adjustment of status in the United States. It is not a discretionary thing. It does not come under discretionary application. In fact, the section 245N was created specifically for immigrant investors. So there is no policy, no USCIS policy or memorandum or anything can change that. It is a statutory provision. The second option for an investor may also apply for immigrant visa at the embassy upon the approval of the Form I-526E. So an investor they have two options. They can either apply for immigrant visa at the embassy or apply for adjustment of status here in the United States. So this policy does not affect immigrant immigrant investors. Now, there is another category of people that were authorized to apply for adjustment of status in the United States, and this memo cannot change it. That category of people is what is called employment-based forgiveness provision. Employment-based forgiveness provision. Again, this was enacted in Section 245K. Section 245K of the Immigration and Nationality Act. You see, the reason why I'm breaking this thing down is that when the Congress specifically enacted a law for a specific purpose, there is no memo, there is no policy that can change it. It is only the Congress that can change the law. And to be fair to USCIS, they have not said so. It is people who don't understand immigration law that are saying all this nonsense on the social media. USCIS has not said so. But a lot of people, I even saw some write-up that were purely AI transcription, and people were just sending all kinds of things out there. But I am telling you, and I tell you, you can quote me on any of these things that I'm discussing with you. This is what I've done for decades, and I'm very, very familiar with the immigration law. I know virtually every provision of the Immigration and Nationality Act. So I'm not telling you something that I'm guessing. I'm telling you authoritatively what the law says. So INA 245K allow employment-based applicants who have remained in the United States in violation of their status for a period that is less than 180 days to apply for adjustment of status in the US. That is what is called the grace period. For those who have listened to me explain 310 and permanent bar, I always talk about grace period. If you overstay your visa and you are applying for employment-based adjustment of status, you overstay your visa for a period that is less than 180 days, up to 179 days. It is called grace period. This is what is addressed specifically in Section 245K of the Immigration and Nationality Act. So, there is a reason why Congress enacted these laws. So, a law enacted by Congress cannot be altered by a policy, cannot be changed or reversed or cancelled or eliminated by a policy memorandum. This is one of the reasons why I believe that if immigration misapply this policy, it may end up in court. But for now, we have to wait and see how they are going to apply it. So those who are already spreading or calculating how it's going to be applied, they may be in for surprises. Now, I believe that if immigration, for any reason, denied an adjustment of status for employment-based applicants who applied under this 245K, it will be a matter for the court. That will be USCIS overreach, and I'm sure a court will intervene. Now, there is also, now, before I move on to the next one, still talking about 245K, the employment-based adjustment of status. I've seen a lot of people on social media talk about immigrant intent, dual intent visas and non-dual intent visas. According to the memo, even dual intent visas like H1B, the H category and L category. Those are the two specific dual intent visas referenced in the Immigration and Nationality Act. Even for, according to this memo, even for those dual intent visas, they will still have to show discretionary consideration, which in my opinion is also an overreach. But again, until we have specific people affected by this policy, nobody can go to court. And if anybody rushes to court, the case will be dismissed. But I will keep updating you every week until we know specifically how this policy is going to be interpreted by USCIS. Even though I've seen some things, even from some of my colleagues, about some requests for evidence that USCIS is issuing and all of that. Again, that is still not enough to challenge some of these things in court, because I've always stated it on this platform that adjustment of status is a discretionary application. It's a discretionary application most of the time. So it is not an application that can be appealed if the application is denied. So for that reason, you can't rush to court because they deny it on what's the right word now? On discretionary basis. The only thing is you have to show that it is not denied in violation of the law. And I'm still going to address all of that. That's why I said today I'm going to spend a lot of time on this memo. So I know that when we go into question and answer, I'm probably going to be getting questions like, is R1? Because I know that I have a lot of pastors, ministers who are in the R1 category. They will be asking whether R1 is a dual intent visa or non-dual intent. As I said before, the Immigration and Nationality Act did not specifically address R1 as a dual intent. However, FAM, Foreign Affairs Manual, actually stated that adjustment of status cannot be denied merely because somebody on R1 applied for an immigrant visa or an immigrant petition. So technically, it can be considered a dual intent visa. But the challenge I see here for those who are on R1, I foresee a situation where USCIS will be distinguishing between someone who entered the US on R visa versus somebody who entered the US on a B1, B2 visa and then change to R1 without going back to the embassy to apply for R1 visa. I foresee that. And that may actually give immigration some leeway in really dealing with that issue. But generally, specifically talking about what the Immigration and Nationality Act reference, R visa is not one of them. But the Foreign Affairs Manual, which is what governs the consular authorities, that is the Foreign Affairs Manual. That is what governs the consular authority. Specifically mentioned that you cannot deny adjustment of status because somebody on R1 status applied for an immigrant petition. So we will still deal with that before. Now, other non-discretionary adjustment bases, they include Nicaraguan adjustment and Central American Relief Act. We call them NACARA, Nicaragua Adjustment and Central American Relief Act. So anybody who is applying for adjustment of status under NACARA, those are statutory provisions that this memo cannot affect. Another one that I have here on my note, Haitian Refugee Immigration Fairness Act, HRIFA. Haiti, this is for Haitian citizens. Haitian Refugee Immigration Fairness Act of 1998. Anybody who is applying for adjustment of status under this provision, this memo does not affect them. The last but not the least I have on my note here is Liberian Refugees Immigration Fairness Act, LRIF. If you are applying for adjustment of status based on Liberian Refugee Immigration Fairness Act, this memo does not affect you because these are adjustment of status specifically authorized by the statute. Now, talking about adjustment of status that are discretionary, that are affected by USCIS discretion, I have about 5 categories on my list. The first one, family-based petition, employment-based petition, DV lottery winners, adjustment of status based on DV lottery. All these 3 categories are discretionary adjustment of status. The next one, special immigrant-based adjustment of status under EB4. If you are applying for adjustment of status as a special immigrant, it falls under the category of discretionary adjustment. The next one, crime victim-based adjustment of status. Maybe you are applying for adjustment of status based on approved U visa or T visa. U visa victims of criminal activities or T visa victims of trafficking. So those type of adjustment of status, they are discretionary. Then the next one, I think that's number 4. Okay, the next one is asylee adjustment. Now, I need to pause here because I see a situation where some people will be confused. When I was listing the non-discretionary adjustment, I mentioned what is the other side of asylum? I mentioned refugee. Thank you. I mentioned refugee. Refugee is statutory adjustment that you cannot do at the embassy. But this time around, when I'm talking about discretionary adjustment, I'm talking about asylee. This is one of the major reasons why it is very, very important for people to understand immigration law so that they don't confuse people. There is a difference between refugee and asylees. Both of them means the same thing, but if you are applying for asylum outside the United States, you are called refugees. If you enter the United States with an approved asylum, those are the people called refugees. So those people cannot apply for adjustment of status. They cannot apply for green card at the embassy. The law only allows them to apply for green card in the US. On the other hand, asylees are those who enter the US. You are already in the US before you apply for asylum. So those are the differences. Because somebody who is already in the US before applying for asylum, it means that when you are applying for visa, you probably didn't mention asylum, or you didn't even apply for visa at all. Maybe you came in through the border and requested asylum. So if you are in that category, you are an asylee. And if your asylum is approved and 1 year after you want to apply for adjustment of status, you fall into the discretionary category. But, okay, let me give you examples of people who come in as refugees. Let's say people who assisted the US in Iraq during Iraq War. People who assisted the US maybe as translators or in any other form. And they were screened. And they realized that having cooperated with the US government, if they left them behind in that place, they probably would be killed. and they decided to grant them refugee status. Or people, I know that in some African countries, I know that Democratic Republic of Congo is one of them. They have refugee resettlement camp where people who are victims of war or who are victims of other forms of persecution, they were brought together in a camp, and from that camp, they apply for refugee status. So if the refugee status was granted and they came into the US as refugees, they can only apply for green card in the US. But if you enter the US on a different visa, or you didn't even come with a visa, and you apply for asylum, then you are an asylee. So that is the difference between a refugee and an asylee. So a refugee, adjustment of status for a refugee is statutory. So this memo does not affect anybody in that category. Adjustment, on the other hand, adjustment of status as an asylee comes under discretionary application. So this memo will affect somebody applying in that category. So I just want to quickly explain that so that before people get confused that, oh, he's saying this one is non-discretionary, now he's saying it's discretionary. No, they are two different things. So there are other discretionary adjustment of status, Cuban, former Soviet Union, Indo-Chinese or Iranian parolees. If they apply for, any of them apply for adjustment of status, it is discretionary. And then diplomat or high-ranking officials at a foreign consulate in the US, if they apply for adjustment of status, those are all discretionary. Those are all discretionary application for adjustment of status. Now, before I move on, because as I said, I have a lot on my list, and I'm going to spend a lot of time trying to explain this so as not to confuse people. I want to discuss briefly people who are going to be severely impacted by this new policy, because different categories of people will be impacted. One will be more than the other. So people who are going to be impacted by the policy. Number one, people who apply for US visa with marital status, with their marital status as married. When you are applying for visa, every visa applicant has to complete, I think it's Form DS-160, non-immigrant visa application. In that form, they always ask for name, date of birth, marital status, and all of that. So if you indicated your marital status in your visa application as married, and then you enter the US, as soon as you enter the US, you married a US citizen. You now claim that, oh, before you apply for visa, you are already in the process of divorce. But when you got to the US, that was when the divorce became final. My brother, my sister, you are going to be severely impacted by this new policy if you are in that category. The second category of people that will be severely impacted by this new policy, people who immediately upon entering the US file for divorce. Again, when you have completed your Form DS-160, marital status, you claim married, and then you came to the US, the first thing you did was to file for divorce. Now, for those who have seen the actual memo, because I know not many people have seen the actual memo, many of them are just relying on the summaries that were posted online. But for those who have seen the actual memo, you will notice that the policy relied heavily on a BIA case, on a 1976 BIA case the policy relied heavily on a 1976 BIA case. Now, what does that case say? The case says that foreign, the case says that the provisions of the Immigration and Nationality Act are supposed to favor the reuniting of families. It would be unreasonable to ascribe to Congress the intention to promote the breakup of aliens' marriages abroad. So what that means is that the BIA said in 1976 that, look, you can't just come to the US, marry a US citizen, and then divorce your wife. As soon as you get to the US, you divorce your wife and you marry a US citizen. No, that is not the intention of Congress for adjustment of status. Even though Congress allowed adjustment of status in the US, but the intention was not to break up families. The intention was not to encourage somebody to come in here and then quickly apply for divorce and divorce your spouse. That is not the intention of the Congress. So that was what that 1976 BIA case said, and that is what USCIS is relying on in doing this. However, what they didn't say is that case also says that if an applicant has been long estranged from his wife or his husband or her husband and come to the United States and married a US citizen, they will view it differently. That is, the BIA said that if somebody has been, maybe you have been long separated from your wife, or you have been divorced long from your wife or from your husband before you come to the US, and then after coming to the US, you married a US citizen, then the court will have looked at that separately. But in a situation where you apply for visa, and in your application, what is your marital status? You stated married. And then you come to the US, the next thing you did is to file for divorce. The BIA said in that case that no, that is not the intent of the Congress for allowing adjustment of status. And that is exactly what USCIS is relying on in coming up with this policy. So people who immediately upon entering the US file for divorce, they will be severely affected by this new policy. The third category of people that will be affected, people who immediately upon entering the US married a US citizen. Even if you have been divorced from your spouse for a long time, then as soon as you enter the US, even though when you apply for visa, you told them you are coming to visit, but as soon as you enter the US, the first thing you did was to marry a US citizen. That means that you actually lied when you apply for visa. So it is not consistent. Your visa application and your marriage is not consistent. Yes, it is true that somebody can fall in love, but what the policy is saying, if you fell in love in these circumstances, you still need to go back to your home country to go and apply for immigrant visa and set the record straight so that your visa application will show that you are coming to the US for the purpose of getting married. The next category of people who will be severely affected by this new policy, people who misrepresented the purpose of coming to the US on their visa application. When you apply for visa, you told them, oh, I'm going for a conference in Florida. And then they ask you, how long are you staying? Oh, I'm just going to be in the conference for 5 days. And then you got to the US and you decided to stay. And the next thing, you married a US citizen. They are saying that you didn't show your true intent at the time you came to the US. And for that reason, you may have to go back home to apply for visa. I'm still going to address some exceptions to some of these things that I'm saying, because there are some exceptions. I'll come back to address that. I'm just giving us information of people who will be severely affected by the new policy. So the next on my list is F1 student. If you are a student seeking adjustment of status, especially before you complete your program, if you tell them you are coming to study in the US and you came in, maybe within the first semester, you are already married. In fact, there are some people who didn't even go to school at all. They got the student visa, entered the US, next thing, they married a US citizen. They are saying, no, people like that may have to go back home to go and apply through the embassy. The next category of people who may be affected, B1, B2 visitors. B1, B2 visitors. And next category of people are employment-based applicant in non-dual intent categories. Employment-based applicant in non-dual intent categories. I mean, examples of non-dual intent visas. O visa, that's alien of extraordinary ability. F visa, that's a student visa. E visa, that's treaty investor. TN visa, that's a Canadian citizen coming temporarily to work in the US. J visa, that's those ones are not even allowed to apply for adjustment of status anyway, because of the 2-year foreign residency requirement, except they were able to obtain a waiver of the 2-year foreign residency. And of course, everyone who entered the US with a visa waiver, all those categories of people will be affected, because if you tell them you are coming in temporarily and then you got here, the first thing you did was to get married and apply for adjustment of status, you may have some questions to answer. It doesn't necessarily mean that the application is going to be denied. That's a point that I also want us to understand. It is just that USCIS adjudicators has been given additional consideration before an application for adjustment of status under these categories will be approved. Now, according to American Immigration Lawyers Association, because one of the reasons why I delayed in responding to many of the people who send me questions about this, I wanted to be sure of my facts, and I wanted to be sure that whatever I say on this program is actually the authority, not that I'm guessing, not that I'm saying, oh, maybe, maybe not. No. Whatever we say here, it is either been verified, and if it is not verified, I would let you know that we don't know yet. For example, we still don't know how USCIS is going to be implementing this. We still don't know the details, and that is why nobody at this stage can file any lawsuit to challenge them. They must implement it first. People must be impacted before they can have the right to sue. That is what is called local standard. So now, according to American Immigration Lawyers Association yesterday, they told us that USCIS officers have started issuing requests for evidence, and they have started asking questions during interviews about why applicants elected to apply for adjustment of status instead of applying for immigrant visa abroad. They told us that some members of American Immigration Lawyers Association have reported that they have received a request for evidence or request for evidences that asking them to explain why they are applying for adjustment of status in the US instead of going to apply for consular processing. So, American Immigration Lawyers Association told us that officers are specifically instructed to weigh the following as adverse factors. That is, they should consider some of these, let me see, 1, 2, 3, 4, 5, 6. Okay, 6 things that I'm going to be talking about as a basis for denying application for adjustment of status. The first one, they have been asked to consider violation of immigration law or conditions of a prior status. In other words, have you been violating the immigration law since you entered the U.S.? Those are some of the things that USCIS adjudicators have been authorized to consider in determining whether to approve a petition or an application for green card or not. This next thing is fraud or false testimony in dealing with USCIS or any government agency. So they have been authorized to look at whether you have been fraudulent with them in the past, whether you have submitted fraudulent documents to immigration in the past, whether you have lied to USCIS officer in the past. Let me quickly pause here before I go on. As a Nigerian, myself, as a Nigerian American, I can tell you that a lot of Nigerians are going to be caught up in this particular consideration, because many people who have either used a fake divorce decree and then maybe after subsequently decided to do a proper divorce here in the US, or maybe you have submitted one declaration of age which subsequently conflicted with another document that has your date of birth. All those things, they are going to be negative consideration for the purpose of adjudicating the adjustment of status application. This is what part of the information given to us by American Immigration Lawyers Association. The next thing that immigration adjudicators have been asked to consider is conduct inconsistent with the purpose of the non-immigrant or parole status. Again, if you told them, either when you apply for visa or at the point of entry, that you are coming for a specific purpose, and then you did not go to that, you did not attend that purpose, again, that is another thing that adjudicators has been authorized to review. Now, let me say this. Even before the new policy came into effect, personally in this office, we have previously received requests for evidence where USCIS will ask, oh, when you apply for visa, you said you are going to visit Disney World in Florida. Show us evidence that you actually went to Disney World. We want to see evidence that you actually went to Florida. So all those things, we have actually received a request for evidence in that line before. But now, according to the instruction given to USCIS adjudicators, those are going to be specific requirements now for anyone applying for adjustment of status under the discretionary standard. Then the next one, the next consideration, according to American Immigration Lawyers Association, is that failure to depart when the purpose of admission or parole was accomplished. If you told them that you are coming to attend a program for 2 weeks, so what happened after 2 weeks? If you didn't depart, you may need to provide an explanation as to why you did not depart, and that may be a consideration according to the new information provided to USCIS adjudicator. Again, talking about this particular policy, I have a friend who came to visit me last December or this year? Recently. He came to visit me from Nigeria recently. This is somebody who has been attending a program, agricultural related program, for the past 20 years. and he has never, not for once, overstayed. In fact, every time he comes in, he probably stay maximum of 1 week. He has never stayed in the US for up to 2 weeks, talk less of overstay. And he has been coming for more than 20 years. This last time that he came, I think it was in February. This last time that he came, they asked him at the port of entry, how long is this program you are doing? No, the first question was, how long are you staying? He said that I will be staying about a week. They said, how long is the program that you are attending? He said 3 days. And he's like, okay, if your program is 3 days, why do you need to stay for 1 week? He said, well, after attending the program, I intend to visit my friend in Dallas. And according to him, I was not there. This is the information he gave me. He said that the officer said, oh, that means what you told us that you are coming for a program is actually not true. It means you are actually here to go and visit your friend, not to attend the program. So my friend was a little angry. What do you mean? I've been attending this program for more than 20 years. I just said I'm going to stop by and say hello to my friend before going back to my home country. And he said, the officer said, shut up. If you say one more word, I will deny you entry now. And of course, he had to keep quiet. And the officer gave him exactly 1 week and told him that if you overstay 1 day, you will never enter this country again. Again, all this happened even before this policy. So that is just telling you that this is not something that is completely strange. Now, the next category, the next thing, according to American Immigration Lawyers Association, the information given to USCIS adjudicators is that applying for adjustment of status in a category where consular processing is available, officers must consider someone who is applying for adjustment of status in a category where consular processing is available. Like I said, it is not in every category that consular process is available. And I already gave a few examples of where consular process is not available. But in this case, they are specifically telling adjudicators that if a consular process is available, they must consider it. They cannot just approve the adjustment of status. They must consider whether consular process is available or not. And the last on the list of the information given to adjudicators is that the adjudicators must consider intent to circumvent the ordinary consular process. That is, they must consider whether this applicant has preconceived intent. Meaning that before you left your home country, did you already determine that, oh, you are going to the US to go and apply for a green card? Meanwhile, when you apply for visa, all you told them was that, oh, I'm going there to attend a program for 3 days. So those kind of preconceived, especially where you are not able to provide evidence that you actually attended that program, then that will show preconceived intent. And of course, that is one of those things that officers have been instructed to consider. Now, the mere fact that officers have been instructed to consider these things does not mean that your application for adjustment of status is going to be denied. No, that is not what it means. It means that they have been instructed to consider it. Now, if you fall into one of these categories, how do you overcome that ground? So, in order to overcome it, you have to present positive factors, or what I call positive equities. Let me share a testimony with my listeners. Last Friday, this policy, although the policy was dated May 21, which was Thursday, it was released on Friday morning, which was 22nd. That was when the policy was released. I was preparing for a trial at the immigration court when the policy was released. I was preparing for an asylum individual hearing on that Friday, last Friday, when this policy was released. So I quickly, because I was really concerned that, maybe with this policy now, it may even affect the case I was going for in court. Even though the case was not adjustment of status, it was purely asylum case. The client has not gotten to the adjustment of status level yet. But I read through the policy. Now, at the conclusion of that trial, the judge asked us to make our closing argument. Of course, ICE lawyers have to go first. So they presented their own closing argument. So when it was my turn, after I presented the entire closing argument, because I read this policy, I now went into positive equities. Even though I didn't know at that time that USCIS was going to tell adjudicators to consider positive equities or not. But I went into positive equities. I mean, this is one of the areas where experience comes in. So I started discussing all the positive equities. And I told the judge that, look, you have to weigh the positive equities versus the negative equity. Put them on the scale of Lady Justice. And whichever tilts against the other, that is what you should consider. And in the case of that particular client, the only negative equity was overstay. Other than that, there was no negative. So I presented all the positive equities. And of course, why did I bring it up? Number one, the asylum was granted by the immigration judge. And those who are spreading rumor that they don't approve asylum for Nigerians and all of that, all those things are bullshit, BS. Sorry for using foul language. Yeah, those things are BS. In this office, I continue to get asylum approved in court all the time. And that is why sometimes it is good to share this thing, to dispel all these rumors that are going on within the community. So, as I was saying, the reason I'm bringing it up, number one, the judge granted the asylum. And this was a client from Nigeria. So those who are thinking, maybe it's not from the travel ban countries. No, this was a client from Nigeria. So the point I'm making, number one, the asylum was granted. Number two, the judge specifically mentioned that he was impressed that we made his job easy with the presentation. So that is why I chip that in. But let me say this. For the purpose of those who may be affected by these policies, positive factors that USCIS is going to be considering. One, family ties in the United States. They will consider your family ties in the United States. You know what? Maybe in order to allow my listeners to properly understand this thing before I go into the positive factors, I want to say that this discretionary application for adjustment may not affect immediate family of a U.S. citizen the same way it will affect extended family members under the family category. Immediate family of U.S. citizen, they include the parents of a U.S. citizen, the spouse of a U.S. citizen, and minor children of a U.S. citizen. So the policy may not affect them the same way it will affect others. But of course, you still have to provide positive equities. So talking about positive equities, the first one on my list, family ties in the United States. Okay, you are applying for adjustment of status. What is your family ties? Maybe you have U.S. citizen children, and going to the consulate to apply for immigrant visa is going to create extreme hardship for your children. It may be financial hardship. Maybe you have 3 children. Now, if you have to go, you have to buy tickets, not only for yourself, but for 4 people. And when you also go, Do you have family ties in your home country? Or maybe you no longer have family ties there. Maybe now you have to stay at hotel. Maybe now you have to be fearful for your children and all of that. So family ties in the US is going to be a positive factor. The next one, applicant moral character. To show that you don't have a criminal record, that will be a positive factor. For those who have a criminal record, depending on the nature of the crime, you may need to show rehabilitation. You may need to show evidence of rehabilitation. You may need to show evidence of a change, that you are now a changed person. So that is talking about good moral character. The third thing on my list is national interest considerations. National interest considerations. So that include that what is going to be the economic benefit of your presence in the US? What are you bringing to the table? I will say, in my opinion, this is my opinion, this is not law, this is my opinion. I will say, in my opinion, that somebody who got EB2 NIW approved may actually have positive consideration in terms of national benefit, national interest benefit. I mean, whatever it is that USCIS consider in approving your EB2 NIW, because NIW is already saying that we are approving this in the national interest of the United States. So that same national interest will be a valid reason why you are eligible for adjustment of status without having to go back to the consulate. So the next one, number 4 on my list of positive consideration. Now, evidence demonstrating, okay, before I go into number 4, when I talk about positive factors, I want to give examples of what constitute positive factors. Those examples are maybe volunteer work. If you are doing volunteer work, volunteer work maybe at the city, at the county level, even at the state level. Let me quickly chip this in, because I know I'm going to still address it before I go into questions. This is an election year. There is midterm election right now. This year presents a very good opportunity for volunteer work. You don't have to be a US citizen to volunteer. Look for the local congressman, local senator, local governor, anyone running for state house, state senate, state houses, any politician, go and volunteer. This year presents in fact, this is a perfect timing for volunteer activities. So for as long as you volunteer, you are not working for them, you are not getting paid. At the end of the day, they probably will willingly give you a letter confirming your volunteer activities. This is the best time if you are considering building positive factors, which I believe it will be extremely necessary for you to do. So that's one. Volunteer work, religious involvement, mentorship activities, leadership or involvement in non-profit or cultural organization, educational achievement, military service, caregiver responsibility, home country conditions, humanitarian consideration like medical conditions, mental health concerns. These are examples of what constitutes good moral character. Good moral character. So for the purpose of good moral character, volunteer work, religious involvement, mentorship activities, leadership or involvement in non-profit or cultural organizations, educational achievement, military service, caregiver responsibilities, home country conditions, humanitarian considerations like medical conditions and mental health concern. All these constitute positive factors if you are trying to apply for adjustment of status at this time, post this policy. Okay, now the next thing that constitutes positive factors, evidence of deep U.S. family ties. That is, maybe you have U.S. citizen spouses or spouse, children, particularly where separation will cause hardship. Another one on my list is long-term lawful presence and community integration. That is, your employment history, your tax record, civic involvement, community letters from different community leaders. All these will be evidence of positive factors for consideration of discretionary considerations. The next one on my list is good moral character. I think I mentioned that before. Maybe I wrote it twice. Good moral character, meaning you don't have criminal record, you have charitable contributions, maybe you have professional accomplishment. So all that will also be evidence of positive factors. The next thing on my list is that you have to demonstrate a benefit to the United States. You have to demonstrate a benefit to the United States. So what that means is that you have to show that maybe you have employer sponsorship letters. Maybe you are a researcher. You have participated in different seminars, webinars, all those things, and you also have maybe specialized skills that you believe will be beneficial to the United States. And of course, it also includes economic contributions to this country, economic contributions. Now, another positive factor for the purpose of adjustment of status under this new policy, home ownership. Do you own a home? Do you pay property tax? Of course, if you own a home, you probably will pay property tax, but get evidence of property tax payment. You know that property tax always include hospital donations, school district, county tax, city tax, all those things. So you need a good lawyer that will help you analyze and package all these positive considerations. It is not enough. It may not be enough for you to just say, oh, I own a home. No, you have to break it down. You have to flaunt your own achievement, your own contribution. Look, I own a home. Every year, I pay $10,000 in property tax, out of which $2,500 help the hospital communities in my county. Another $2,500 go to help my school district, even though I don't even have any child in that school district. But if you do, you can be silent on that, and you still say that, with my tax that I pay, I help fund this independent school district. You flaunt all these things. That, look, with my property tax, I help to also fund the city that I live in. I help to fund the county that I live in. So you package it in such a way that it will be considered a positive factor. So it is not enough to just say that, oh, you know what, I own a home in the US. No, you still have to explain it. Now, the last thing on my list for this particular point of positive factors is that compliance with immigration law. You also have to show that, look, since I came in, I've been complying with immigration law. Even though I came in as a visitor, before the expiration of my status, I applied for extension of status and it was approved. So I continue to maintain status. Before the expiration of that extension, I applied for a change of status, which was approved. You can see that I've always respected the law in this country. I've always obeyed the law. I've not done anything in violation of the law. All this will be considered positive factors. Now, before we proceed, I want to talk about what if an application is denied under this new policy. What are people going to do? What are the considerations? What are the options? What can be done? Before I address that, I want to remind my listeners, I've always explained it under this, during my podcast here from time to time, that when you are in the US, the law is different from when you step out of the US. If you stay in the US and you overstay your visa or you overstay your I-94, your legal presence in the US for a period that is less than 180 days, that's the same INA 245K that I refer to. If you violate your status, especially for employment-based applicant, for a period that is less than 180 days, that is considered a grace period. If you violate your status for a period of 180 days or more, but less than 1 year, anytime you step out of the US, you are going to be barred from re-entering the US for a period of 3 years. That is what is called 3-year bar. If you overstay your visa for a period of 1 year or more, anytime you step out of the US, you will be barred from returning to the US for a period of 10 years. That is what is called 10-year bar. If you overstay your legal presence for a period of 1 year or more, and you step out of the US, and you re-enter the US illegally, it's a permanent bar. No marriage, no employer, no petition can fix it. It's a permanent bar. So, you have to be careful because a lot of people are going to be getting advice. Oh, why don't you just go back home, go and apply from home? Yes, if you are eligible to apply from home, yes, that may be a good thing for you. But it is not everybody that is eligible. That is why I'm re-explaining the 3-year bar, the 10-year bar, and the permanent bar. So, before you take that decision to go back home, consult an experienced immigration attorney. Determine if you are eligible to apply from the consulate. Determine if you are barred, if you will be able to come back to this country, because if you step out, you may not be able to come back. So that is one implication that I want us to pay attention to. Now, how do we navigate this policy? I have some suggestions. If you have consulted with an experienced immigration attorney and you realize that this policy will affect you and you may need to go back home to go and apply, the first suggestion I have for you, consider filing I-601A. Consider filing I-601A. It is called unlawful presence waiver. Consider filing I-601A. Why is that important? You can only file I-601A while in the US. Once you step out of the country, you cannot file I-601A. It is something that you can file only when you are in the US. So, if you already know that your situation is such that you may end up applying from outside, your case may end up being denied. Don't wait until it is denied. Go ahead and file I-601A, unlawful presence waiver. It is important that you start early for two reasons. One, right now, the current processing period is about 2 years. Secondly, once you step out, you will no longer be able to apply for it. So it is only available for people who are physically present in the US. I-601A is different from I-601. I-601 is waiver of ground of inadmissibility. I-601 is called waiver of ground of inadmissibility. I-601A is unlawful presence waiver. There are two different things. For I-601, you can apply for the waiver in the US, or you apply outside the US after your immigrant visa is already denied. But for I-601A, you don't need to apply for immigrant visa and be denied first. And two, you must apply while you are still in the US. So that is the benefit. So that's one thing I would tell people to consider doing if you are eligible. The next thing I will advise people on how to navigate the policy. Again, if you already know that your case is going to be denied because you fall into this category, consider if you will need to file I-601 or I-212 waiver if you decide to go back to your home country. Consider it and know your option before you depart, even if your I-485 is denied. Because if you are going to be affected by the permanent bar, you may not even, it is something that you need to know so that you don't step out and then realize after you are out of the country that you cannot come back to this country. Then the next thing that I'm going to advise on how to navigate the policy, and I think I mentioned this earlier, proactively build positive equity in support of discretionary application. That is one of the reasons why I explain how can you build positive equities. Don't wait until immigration asks for it. Don't wait until your case is denied. Start now. And I said, this is a perfect timing. This is an election year. Volunteer. Go to your city. Volunteer in that place. In some cities, they have something called adopt a highway. It's not that you are going to build a highway or anything. All it just means is that you can say that, oh, you know what, between Cooper Street and Matlock Road, I want to be responsible for cleaning this area. Apply to the city. They will give you permission to do it, and they will readily give you certificate after to thank you. So get involved, build proactively. Don't wait until immigration starts issuing requests for evidence for you before you start this thing. So start now, proactive. Participate in election, volunteer with all these politicians. There is no city in the entire United States now where you will not have politicians who are running for elections. This is a perfect timing. Participate. Volunteer your time. You may be helping them to make phone calls. You may be helping them to spread flyers. You may be helping them to compile list of possible voters. I mean, whatever it is that you can do, this is the time to start building the positive equities proactively. Next one. If you are going to apply for adjustment of status, or if you already have an adjustment application, don't wait for immigration to ask questions. Package a very solid case. Ensure that you include substantial evidence in your category, including evidence of positive equities. Don't wait for them to ask for it. Send it in. Especially if you are just going to apply, make sure that you have overwhelming evidence of positive equities. Build how can I explain this? I don't know why certain words are disappearing from my head. persuasive, Build a very strong, persuasive human story. Always remember, immigration officers, they are human too. I can tell you from experience, I have conducted a trial before at the immigration court where I saw the judge take a tissue to wipe her face. I pretended as if I didn't notice it because I didn't want to be caught up in maybe embarrassing situation or awkward situation. But make a persuasive story. Let the officer who is going to adjudicate your case read it. Let the officer be the one that will be making a case for you, defending you. Make a very strong, persuasive case. We have the opportunity now. This is an advance notice. Don't wait till the last minute. I've seen people file adjustment application that was bare bone. No evidence. Attach overwhelming evidence. In my practice, I have been to interview before where the officer specifically said that, oh, these documents are too much. I don't need all of this. There's nothing wrong if they said that your document is too much. But a lot is wrong if they say you don't have enough. Because that could be a reason, a basis for denial. Now, I still have a lot to say, but I see that it's almost 1.5 hours. So let's go into some questions. We'll continue next week on, like I said, this week I was actually going to talk about how to avoid USCIS rejecting your application due to common errors. But I'm going to postpone that till next week because this issue of the 245 adjustment policy is material, and that is what we have discussed. So let's quickly see how many questions we can answer. I believe that a lot of questions will have been answered with this very detailed explanation. So I will not, any question that has already been answered, let's keep that. Let's go into as many as we can. Okay. Good afternoon, Dr. Olu. A blessed happy day to you and your team. I'm the father of a U.S. citizen. My green card was approved on March 27, 2026. I completed my biometrics with USCIS on March. You see, this is probably misapplication of fact, because if the green card was already approved in March, why would she? Maybe you wanted to say my I-130 was submitted in March, because you don't do biometrics after approval. Right. So if it says my green card was approved on March 27, then why would they need biometrics in May? Anyway, is that a follow-up? What's the question? Yeah. Will USCIS put my case on hold as a result of the newly released memo? What will be the next stage of my case after the biometrics? So definitely it can't be approval. So it must be misapplication of fact. Well, I think I've actually answered this question in my explanation, but I will just summarize it. Your application is, what was that first question? Will my case be put on hold? No. Actually, I think that the pause thing, you know, I always say it on this podcast that this time that USCIS is pausing application and all of that, that whenever they are going to resume, they are going to come up with draconian policies and all of that. And I think they have. I believe that this new policy is what they were waiting for. Because right now, I mean, this cannot be a coincidence. Between Friday that they released this policy and today, they have actually started inviting people from the travel ban countries. They have started inviting them for interviews again. They have started adjudicating their cases. They have started issuing requests for evidence between Friday and now. So I believe that your case is not going to be put on hold. But I want you to follow the advice that I've given on this new policy. Proactively start gathering evidence of positive equities. Your case is not going to be affected. In my opinion, your case is not going to be affected by the policy as to send you back to your home country because you fall into the category of immediate family of a US citizen. But at the same time, immigration may issue a request for evidence asking you for those positive equities to be considered. So my advice for you, start building the positive equities. I've given all different samples of what constitute positive equities, but especially the volunteer part. Ensure you don't have criminal record. Go ahead and start volunteering. I mean, get involved in your religious community. Get involved with your neighbors, with your city and all of that. So, but yes, they will. The next stage in your case will probably be an interview. They will probably schedule an interview for you. Next question, please. Good day, sir. Is it true they are now processing N400 for citizenship because of the new policy of FBI connected to new applicants for countries that are still under check? Well, as I just said, now we have noticed since last week, since Friday when they released this new policy, suddenly they've started inviting our client for interview, which suggests that they have started processing it. We have seen interview for people with pending asylum. We have seen interview for people with pending adjustment application. We have also seen interview for people with pending citizenship application. So it will not be far from the truth to say that they have actually resumed processing. Next question. Dr. Asekun and crew, blessed week to you all. Thank you. Next one, please. God bless you and your team, sir. Amen. Thank you. Thank you. Next question. Hello. Does the new USS memo affect T-visa applicants applying for green card? Oh, yes. I'm sure that this person didn't start with us. It does. It does. T-visa is one of the discretionary applications. And that's why I broke it down from the beginning. It affects every discretionary application. It doesn't, like I said, it doesn't mean they are going to deny it. It simply means that you will be asked to provide positive consideration, positive equities for consideration in determining discretion. Next question. Sir, can the new law on green card policy affect removal conditions for 10-year green card? Well, it is not supposed to, because somebody who already has a conditional green card is not applying for adjustment of status. You have already crossed that bridge. What you are applying for is removal of condition, which is going to be entirely about your relationship with your U.S. citizen spouse. So I believe you have crossed that hurdle. But the hurdle of good moral character can still come because, like I said, you probably will still need to apply for citizenship in the future. So you can also start building the positive equities right now. Next question, please. Good afternoon to you, Dr. Asekun and team. God bless you. I want to transfer my case from Atlanta to Chicago, where I live. Master hearing is in few months. Never lived in Atlanta before. Move it forward. I think that's a continuation. Okay, the judge has been there since 2021. Or maybe he wanted to say the case has been there since 2021. Do you think I will encounter any problem? Master hearing is September. My friends are saying just ignore the whole thing until after Trump, that the court is a trap. But I'm worried it might put me in a more difficult situation later. Well, I'm not sure if this person started the podcast with us, because if you do, one of the things I spoke about at the beginning of this podcast today, I spoke about the new ICE proposal. And let me go back to that policy for the purpose of those who join late. ICE is proposing increasing the fee for removal in absentia from $5,130 to $18,000. The One Big Beautiful Bill Act created a new enforcement fee for certain non-citizens for failing to appear at the immigration court and were arrested by ICE. Now, what does this mean for the purpose of those who join us late? It means that if you don't show up at a removal hearing and the court order you removed in absentia, if ICE arrest you, before they can even listen to anything, you have to put down $18,000. So, number one, those who are telling you to ignore the case, I don't know if they will contribute $18,000 to give you when you are arrested by ICE. And even if they do, after putting down the $18,000, there is no guarantee that you will be released on bond. There is no guarantee that your motion to reopen will be approved, because for a motion to reopen in absentia order to be reopened, you have to be approved. For the motion to be approved, you have to show a valid reason why you didn't appear. And the only valid reason, to the best of my knowledge, that I know of, one, health ground. And for those health ground, you will need to have medical records to back it up. Two, lack of notice. You have to show that you didn't receive notice of the hearing. And for that lack of notice reason to be valid, you have to show that you didn't change your address without providing a change of address to the government. Because for non-citizens, it is the responsibility of non-citizens to provide a new address whenever they change their address. So if you change your address and you didn't provide an address to them, and then they send a notice to appear to the wrong address and you didn't know about it and you are ordered removed in absentia, if you file a motion to reopen, they will deny it because it is your responsibility to provide a new address. So it is not a good advice for you to abandon the court process. Go and attend the court process. Worst case scenario, you still have the opportunity to present your case. You have the opportunity to present a relief. And even if you have a valid relief and you know that the court may not grant it, you can still apply for voluntary departure and then go back home to apply for immigrant visa and apply for a waiver. So evaluate your options very well. Don't listen to people who will create more problem for you. $18,000 is a lot of money. And I don't know how many people will be able to raise it if they are picked up by ICE after being ordered removed in absentia, which is what is going to happen if you don't show up in court. Now, talking about change of address, a change of venue of the case. Yes, you can apply for a change of venue, but the court will want to see evidence that you actually live in the new place where you want the case to be transferred to. I think he said from Atlanta to Chicago. Yes. So if you want the case to be transferred from Atlanta to Chicago, you have to provide evidence that you are actually living in Chicago. You have to show evidence of utility bills, electricity or water. They don't consider phone bill, even though phone may be utility, but for this purpose, phone is not considered. What is considered is electricity or water bill. So you have to show evidence that that is your real address. So once you show that, then attach that to your motion to change venue, and then the case will be transferred to the new venue. But sometimes you may also want to know who your judge is, because sometimes you don't want to run from pan to fire. If you have a good judge where the case is currently is, you may consider leaving it there. Because a lot of people have the erroneous belief that once you do a change of venue, that is going to give you time. Not under the current administration. It's not going to give you any time. In fact, some judges will ask you to plead. They will ask you to enter written pleadings before they can grant a motion for change of venue. So which means that you are not saving any time. Nothing.
So there's an additional, she said that she never received, or they said that they never received the NTA, so they couldn't even do the written pleadings.
Okay, or should I just apply to appear to webinar? I don't just want to ignore it, even though I never received an NTA in the mail, only saw it online. I'm sure that this is probably one of the victims of a change of address. You probably have moved and you have not done your change of address. That's probably why you didn't receive a notice to appear. What I will tell you is probably to consult with an experienced immigration attorney so that they can review your case. You see, there are certain things that we can give general information, but there are certain things that may require specific questioning in order to give you an accurate advice. But one thing I'm going to tell you is that if you are a listener on this program, always check your EOIR case portal. Go to Google, type in EOIR case status lookup. Put in your alien number, put in your country of citizenship, and you will know if you have a case pending or not, whether you receive NTA or not. You don't want to be ordered removed in absentia, especially with the proposal of $18,000. That is not what you want to do. So I'm still going to advise this person not to ignore the court. Go ahead and appear. On that day, you can actually appear in court and tell the court that you didn't receive an NTA. The government lawyer representing you eyes on that day will provide you another copy. Or, best case scenario, hire a lawyer who could also enter appearance on your behalf and also tell the court that you did not receive a notice to appear. Can you apply for WebEx hearing? Yes. Will the court grant it? I don't know. A lot depends on individual judges. I know that for lawyers, they will grant it, but for respondents, will they grant it? I honestly don't know. All these things depend on individual judges. And that is one of the reasons why you need to find out more about the judge who is currently handling your case before you request a transfer, so that you don't run from frying pan to fire. Next question, please. Oh, thank you, sir, for your help to humanity. God bless you. Amen. Amen. Okay. EB1A, I-140 premium processing receipt date of November 26, 2025. RFE issued on December 16, 2025. RFE response was acknowledged as received by USCIS on March 12, 2026. Move it up a bit. Oh, is that the only one? Okay, since then, no movement on my petition. Can I request a refund of the premium processing fee? Oh, yes, you can do. Sometimes USCIS on their own will send you a message that they will refund your premium processing fee. But I can tell you, in my decades of practice, have we ever received, I think only once have I received a refund since I've been doing this. Huh? Yeah, I remember. It was only one. Yeah. I mean, it was only one refund that I've ever received, and they just reminded me in the office here that one refund was for a staff that this law office petitioned for. Yeah. So, and I'm sure this was probably 15, 20 years ago.
2015.
Oh, that was 2015.
2005.
No, it's 2000. That was 21 years ago.
Yes. Yeah.
That was 21 years ago. So we've only received a refund one time, and that was 21 years ago. So yes, you can request it, but will they grant it? Will they actually send you the money? I doubt it. Like I said, if in my entire practice we have only received a refund. Yeah, but from time to time we receive notification that they will refund. In fact, we still received one last week that they will refund the premium processing. But it's one thing to receive notifications, another thing to actually receive the money. So next question, please.
This one? Or wait. No, this is someone else. Oh, no, you're right. Sorry.
I have a master hearing coming. Came in when I was 11 years. Filed asylum after 1 year. Was sent to immigration court, but just have a date. Now I'm 19 years with no criminal record. Should I be worried about ICE? This person didn't say the manner of entry. He didn't say the manner of entry, even though he came in when he was 11, but did he come in with a visa or did he come in without a visa? Well, I will answer it both ways. If you did not enter with a visa, should you be worried about ICE? Yes. However, the fact that you don't have criminal record, hold on, take out 11 from 19. That's 8 years. Oh, he just came in 8 years ago. Okay, I was trying to calculate whether he was eligible for DACA, but he just came in 8 years ago. No, DACA was since 2012, so he may not even be eligible for that. And besides, some court have even put an injunction on new DACA applications. So should you be worried about ICE? I will say yes. However, it is not in all cases. I mean, like I said, I don't know whether it is sheer luck, whether it is preparation, whether it is skill, whether it is observance of the law, knowledge of the law. I don't know for sure. But what I can tell you is that since Donald Trump came in, was sworn in January 20 of 2025, as of today, I don't have one single client who was detained in court or who was picked up by ICE in court. Not one. But again, does that mean they don't pick people up? They do. So I don't want you to misquote me. So I can't tell you authoritatively that you are safe from ICE. But what is the alternative? Should you not go to court? No, I will discourage that. It is better to go to court, even if the worst happened. You can still fight it than not showing up, having a in absentia removal order issued against you, you getting arrested by ICE, asking you to deposit $18,000, which may still not have guarantee. And now, when you are going to be facing discretionary issue, they will also use the fact that you didn't show up in court. They will use it against you as one of the evidence that you do not deserve discretionary consideration. So you have to weigh the options. What is the effect if you don't show up? And how will that impact your ability to even get a relief in the future? So considering the totality, the risk of not showing up clearly outweigh the risk of being arrested at the immigration court. I will still show up, but again, I'm yet to have a client detained at the court, so I can't tell you for certain that they will not arrest you or that they will arrest you. But should you have reasons to be concerned? Yes, you should. Next question. Good day, Dr. Olu and team. Thank you for all you do, sir. Please, with the recent green card update, does it affect those with approved I-360 special immigrant religious visa? I'm sure this person either came in late or sent the question before I started explaining it. Yes, it does. But does it mean it will not be approved? No, it doesn't. So what should you be doing right now? start putting together evidence of positive consideration, as highlighted in my initial conversation today. If you join us late, I will advise that at your convenience, go back and replay today's podcast, because I'm not going to go back now. I need to answer a few more questions before we leave. Next question. Good afternoon, sir. Please, any new hope on removing the ban? We don't know yet. That's going to be reviewed next month, end of June. That's when the 180 days will complete. That's when we will know whether certain countries will be removed from the list of banned countries or not. So we still have 1 more month to go.
The person that you answered the question earlier, that you didn't know whether she had entered DWI or with a visa.
Yes.
She said she came in with a visa. The one that entered.
Oh, okay. Yeah, if he came in with a if she came in with a visa, the possibility of being arrested is even lower. The possibility of being arrested is low. Next question. Good afternoon, sir. How can we still get green card with this memo? This has broken me. My filing is through my child. Well, I don't think you are affected, ma. What you should be paying attention right now is to put together the positive equities. Positive equities. And I've explained all the different examples of what constitute positive equities. If you join us late, please go back and replay today's podcast, ma, because I've actually spent a lot of time. I think I spent almost 1 hour, 30 minutes discussing all these things. So it's not fair to go back again and avoid questions that could have been answered. But this person is not affected. Just go back and listen to it. And if you did, just make sure you start putting together evidence of positive equities. Okay, next question. I just applied for adjustment of status after my EB2 NIW approval, and I have a newborn that's a U.S. citizen. I am maintaining lawful status as I am F1. Would this help my adjustment of status after? Oh yes, it will. The fact that you are maintaining status is a positive equity. The fact that you have a U.S. citizen child is a positive equity. But again, go ahead and do other things. Go and make sure you get involved in your religious activities. Make sure you do a lot of volunteer work. Go back and listen to today's podcast for examples of how to build positive equities. Next question. Good day, Doc. I have active I-130 485. Traveled on parole to Nigeria last week. Can I still return back safely? No criminal record. Oh yes. You can return safely, but make sure you check your case. I don't know if you have an online account. Make sure you check it, because as I said before, they have started inviting people for interview right now, so that you don't miss an interview while you are abroad. But can you come back safely? Oh yes, nothing has changed. You can still come back. Next question. Good morning, sir. In view of the new memo, can someone with a 48-month extension travel to Nigeria? 2. Can someone with edit stamp travel also? Thank you. Oh yes to both questions. Number one, if you have 48-month extension, I'm assuming that you have a conditional green card. This policy memo does not affect people who already have green card. This is talking about adjustment of status. So if I understand your question correctly, you already have a 2-year green card. What you have pending is called removal of condition. That only requires you to show evidence of good faith, evidence of if this is based on marriage, because there are 2 types of conditional green card: investors and people who are married to U.S. citizens. So if this is based on marriage, make sure you put together evidence of commingling of activities and then evidence of good moral character, but it does not affect or prevent you from traveling. As for the ADT stamp, yes, it's the same thing. If your extension letter expired and your passport is stamped, yes, you can travel with it. That is actually the purpose. Next question. Good day, sir. I'm on H1B, but my 7-year limit is on November 6, 2026. I have a pending EB1 filed personally. Did it move? Okay, let me go back. Good day, sir. I'm on H1B, but my 7-year limit is on November 6, 2026. I have a pending EB1 filed personally. What did it keep moving?
People are commenting.
Okay, people are commenting. Okay. Where did I? Okay. I have a pending EB1 filed personally, filed November 7th, but on pause. My company also recently applied for Schedule A for me. So what's the question? I'm also currently a part-time PhD student. What are my options to continue working if the hold is not removed? Can I ask my employer to apply for H1B extension since my EB1 has been pending? Well, there are still additional information that I will need in order to accurately answer this question or to correctly answer the question, because H1B can be extended beyond 7 years if certain conditions are met. I don't know if these conditions are met in this case. One of the conditions is that, one, you must have a pending application for labor certification that has been pending for more than 1 year. Or two, you must have I-140 that is employment based that has been pending for more than 1 year before the expiration of your H1B. If you meet those conditions, your employer can actually apply for an extension of your H1B and it will be extended beyond the 7-year limit.
Is it every year? Do they extend it for?
Yeah, they will extend it for an increment of 1 year. They are no longer going to give you 3 years like before, but they will extend it. But it can be extended. I mean, I remember I've actually represented a client that was on H1B for almost 12 years. We kept on renewing the H1B. You remember the client?
Doctor, right?
No, it was on mental health something. I don't want to mention the.
From Kenya.
No, I think she was Hispanic.
Oh, I know who you're talking about.
I don't want to mention the name on here. So, yeah, so your H1B can actually be extended well beyond the 7 years if you meet the conditions. Next question. If someone has a pending VAWA and green card application, can it be said that the person is in status? It depends. I don't know if the person applied for VAWA or even, it depends. You see, talking about somebody who has overstayed as somebody who is in status, there are two different things. One, if you have a pending case, if you have a pending application for adjustment of status or a pending application for green card or a pending VAWA that is filed concurrently with adjustment application, are you maintaining legal status? The answer is yes. Have you ever violated your status? That depends on a number of things. Before the VAWA, before the adjustment application, since you came in, has there been a lapse in your status? For example, did you come in with a B1, B2 visa? Were you given 6 months at the port of entry? What happened after the 6 months? Was there any time that you violated your status? So if the answer is yes to any of those, then even though you may be in status right now, if your application is denied, you will still be unlawfully present. But if the application is approved, then it will cure the unlawful presence.
But so right now, they're not lawfully in status, they're just lawfully present.
They are lawfully present, but they are not in lawful status.
Yes, okay.
That's the difference.
Yeah.
So that's why I said I can't answer the question because I don't know whether this person is in lawful status or not. But what I know is that because of the pending adjustment application, you are lawfully present in the U.S. But whether you are in lawful status or not, that depends on whether you have ever been out of status since your entry. So next question. Which one is that a continuation of the previous H1B question? So how can the question start with however? There must be a prior question. Okay, let me read it.
Okay, I don't know why the first one came later.
Okay. My green card and EAD has been pending due to the ban since November 2025. It was a self-petition through I-140. With this new memo, what is my fate? Excuse me. However, I tried to convince my employer. That one says I-140.
Yeah.
I don't think it's the same person.
But it's the same person.
Here, keep reading.
Okay, I tried to convince my employer, as you have suggested, not to terminate my pending H-1B, but they mentioned that they can't wait anymore. Okay,
Yeah.
so this person is on H-1B. Oh, okay. So if the employer cannot wait, you can still try to change employer if the adjustment application has been pending for more than 180 days. There is something called AC-21 that will allow you to change employer without losing your space on the queue. Remember, H-1B is a dual intent visa, so it's not going to affect your adjustment application. But in order to maintain status, you need that H-1B extended. So just change employer if your current employer is not willing to extend it, assuming that your adjustment application has been pending for at least 180 days. If it is less than 180 days, you will not qualify for change of employer, because if you do, the application, the I-140 will automatically be denied. Next question, or even revoked. Okay, good morning, sir. Please, can you explain the latest memo USCIS sent out on leaving the US to apply for green card? Well, we have explained that extensively today. Okay, good afternoon, Dr. Asekun. Thank you all thank you all you and your team do. Okay, for all you and your team do. God bless you all. Amen. Please, does the new policy apply to residents with 2-year green card? Also, I recently changed my address. No, it does not. I already answered that. It's already more than 2 hours. I'm probably going to have to stop in the next 10 minutes. So questions that have been answered should just be skipped.
This person wants to know if she's still
Use the change of address tool on my USS online account. Do I still need to fill? Okay, if you have used the change of address tool online, no, you don't need to. But make sure you print evidence of it. Print evidence of it. Okay, good afternoon, Dr. Asekun and team. You see, hold on before you move that question. You see, this is one of the challenges we have. Look at the way this person spelled my name.
Yeah.
Do you know that if I'm applying for something with immigration, this spelling can lead to a denial based on the recent policies? Yes, my name is Asekun. There is no H. So putting an H can actually get my application denied, assuming that I'm applying for something. Okay. Good afternoon, Dr. Olu Asekun. Well done, sir. God will continue to be with you. More wisdom, sir. Amen. Thank you. Hello, doctor. Please, is it safe to travel with advanced parole with this new policy of 522? I have a pending adjustment of status since 2021 via R1 and I-360. Oh, yes, you can travel. But the only thing you need to be doing, let me say this, for everyone that is thinking about this new policy, spend your time proactively preparing for the positive equities. The new policy is not something that is just going to change things in a draconian way. The new policy has not instructed officers to start denying cases. No, what they ask officers to do is to evaluate the positive consideration against the negative consideration, which was not a requirement prior to now. So that is the change in the policy. So it doesn't stop you from using your advanced parole. You can still use it. Just make sure you don't have criminal record. That's it. Okay. Is it okay to proceed with EB2 NIW application now with the new policy? I came in with F1 visa, then changed to R1, and now have AOS since October 2021. So I don't understand the question. Please go back. Is it okay to proceed with EB2? Why EB2 if you have adjustment of status pending since 2021? That means that visa is actually current, because I believe they were in 2022 or 2023. Huh? No, even for R1, for I-360.
No, I think it was 2020.
Oh, it's
Can you please check? Because this is going to be this is going to be a situation where this person is going to give USCIS the reason to actually scrutinize this application based on this fact. Number one, you probably how did he enter the US again? Did he say he entered as a student?
This is his first question.
No, he just said he has
Okay, this
pending. Did he mention how he entered the US? Okay, yeah, I came in with F1. Aha. This is actually the kind of category that will give USCIS an opportunity to scrutinize the application. So you came in with F1. So the first question is, did you go to school? Did you complete your program in school, or did you just change to R1? Or did you change to R1 after you completed your program? Secondly, what was the nature of your program? Was it a religious program, or was it a secular program? If it was a secular program, then why did you change to R1? These are legitimate questions that immigration can raise. Does it mean they are going to deny it? No. It simply means these are going to be additional consideration under this new policy. But can you change to I-140 EB2 NIW? Yes, you can. But like I said, if you already have a pending adjustment application, I will not bother to do that, because even if you have your family here with a pending adjustment application after the approval of I-360, your family members will have been able to receive employment authorization. So it means that you are perfectly maintaining lawful presence. So I don't see additional need for I-140, because especially under this new policy, I-140 is really scrutinized extensively now. So you don't want to put yourself in a situation where it will seem like your R1 was just something that you apply for just to keep yourself in status or something. Next question, please.
it's 2022.
Oh, they are in 2022. So I was right. So visa is current. He said he's been
October 2021.
is as October, yeah,
21.
and they are currently in 2022.
Oh, you're right. Sorry.
Yeah, visa is current. So what's the benefit? I don't see any benefit, because whatever affected the adjustment based on the approved 360 will definitely affect the I-140, even if the I-140 is approved. But what I would tell this person is that if you have some positive consideration that you believe that will help you for the purpose of applying for EB2 NIW, you can still use this consideration even in responding to an RFE. If immigration issue an RFE for you asking for positive consideration, you can still use it. as additional positive equity. Okay. Oh, okay, 3. Okay. 1, thanks, doctor and team. Is travel with pending notice of intent to revoke response safe? Case involve our approved green card and USCIS concern about foreign divorce decree, not submitting a letter. US divorce for child custody. Is it a continuation?
I think the other two are like
They are different questions.
the same person, but different question.
Okay. Well, I will tell you objectively, traveling out of the country. Oh, you know what? Don't let me assume. This person didn't say the travel, whether is within the country or outside the country. Okay, let me answer it both ways. Traveling within the US, yes, it is safe. Traveling outside the country, the truth of the matter is that you have some level of risk. And the risk is that if your application is eventually, if your green card was eventually revoked while you are outside, that means upon your return, they are probably going to take you into custody and then place you in removal proceedings. So that risk is there. Will it happen? That's not something I can tell you authoritatively. I cannot tell you with 100% certainty that that will happen. But I can tell you that you stand a 50% chance of being detained upon your entry if your green card was revoked while you are outside. But if the notice of intent to revoke remains pending while you are outside, then there is no problem. The only problem is if they revoke it, because the moment it is revoked, it means you will now be considered an arriving alien upon your return. And an arriving alien is subject to mandatory detention. So that is the risk that you face in this one. So the next one, notice of intention to revoke pending 2 years. Is 30 days trip with US citizen minor kid to see old parent after 7 to 8 years okay? Strong US ties, kids, mortgage, work, nursing school, will travel trigger USCIS action in Nigeria? No. If this notice of intent to revoke has been pending for 2 years, I don't think that is something that's going to trigger any movement. If it's going to trigger a movement, it will be your entry, your re-entry that will trigger it, not when you are leaving. And even if your re-entry trigger it, for as long as you are already in the US, you will be okay. So if your notice of intent to revoke has been pending for up to 2 years, then I will advise that it will be okay to travel for not more than 30 days at a time. If anything is going to trigger it, it is your re-entry back to the US. You said 3, I saw only 2. Where's the third one? Oh, okay. Okay, from the same person. Okay. The third question, what's most realistic re-entry outcome? Oh, what's the most realistic re-entry outcome if CBP sees pending NYR, will waiting after 5-year recession window materially improve case? If I go, what document or precautions overstay waiver with US kid? No, I don't think there will be, based on the previous question, I don't think there will be an issue, because you remember when you are going out, you are dealing with the airline. It is when you are returning, that's when you deal with CBP. Yes, if a CBP officer see a notice of intent to revoke on your record, so what? The only thing it can do is to trigger a decision in your case. That is not going to happen while you are there at the airport. So I don't see any issue here. So how many more? We've been on this for 2 hours and 21 minutes. Let me answer the last one and then we stop for today. I'm sure many of the questions are already addressed in the opening this thing, but we can't finish everything in one day. So we will continue the questions next week. We are not going to revisit this. We just continue the questions next week. So let me just answer the last one for today. Good day, sir. I want to know if it's safe for my son, 13-year-old, to go with his mother to Nigeria, to the Nigerian embassy for a visa interview.
U.S. Embassy.
Oh, U.S. Embassy in Nigeria, I guess. So, but he didn't say if the son is a U.S. citizen or not. But either is a citizen or not, there's nothing. If your son is in Nigeria, yeah, there is no risk of going with the mother to the embassy. No, there is no such risk at all. Well, we will have to end this today. You will agree with me that we've spent a lot of time today. This is 2 hours and this is 2:22. We have been on this for 2 hours and 22 minutes, and there was no break in between. I have a lot of other appointments that I have to keep. We'll continue next week by God's grace. In the meantime, always remember, stay out of trouble, especially now that we are talking about positive equities. Remember, driving while under the influence, DUI, DWI, all those things will create problem at this time. Is going to constitute negative equities. Please stay under the radar. Avoid unnecessary attention to yourself. Beware of your postings on social media, including WhatsApp. I've said it under this platform before, that all those end-to-end encryption that WhatsApp was using to sell or to attract customers, those things do not affect American government. They have access to all these WhatsApp messages. So be careful what information you share online. Until next week, I remain yours truly, Dr. Olu Asekun. Remember to join us on all our social media platforms, YouTube, Instagram, X, Facebook, and TikTok. And also, stay safe. God bless you. See you next week.
The case before this honorable court is suit number.
My lord, this conduct was outside the scope of his employment and not authorized by the speaker, my lord.
My lord, it's just like pouring water into a basket that is a sieve.
Which is happening very bending. This position of the lemurs.
The Olu Asekun Foundation, in partnership with Olabisi Onabanjo University Faculty of Law, proudly presents the 2026 Olu Asekun Moot Court Competition. The case before this honorable court is suit number.
My lord,